Criminal Law 1, Indian Penal Code, Chapter 1, Crime, meaning, definition, elements, and stages of crime is the topic for discussion today. This topic is in English media. Previously, I uploaded two lectures. One lecture on general principles and defenses in brief, that is from section 1 to 120b, divided into chapter 1 to 5a. In second lecture, I covered chapter 6 to 23, containing sections for 121 to 511. Today, I wish to take up crime, meaning, definition, elements, namely human being, mens rea, actus reus, and injury, proximate injury. Next, nature, how crime is distinct from other wrongs like tort, breach of contract, and finally, the stages of crime. What are the various stages involved in from beginning to extinction, beginning to accomplishment of crime is what I wish to take up. Dear student friends, before going to commence the topic, let me take just half an hour with your permission to pray God, pay homage to my reverend parents, late Ragaprao, late Srimati Kantaratnam, my eldest brother, Professor Rega Jaganmohan Rao, my wife, Mrs. Balivada Rega Tirumala Gauri, my academic associate. I express my deep sense of gratitude to all my godfathers who are instrumental for my growth and development. It's my duty to express my heartfelt thanks to the publishers in internet, various articles and authors of various articles and research papers, whose articles I am making use of to bring out these lectures before you. Finally, it is my deep sense of it is my duty to express my deep sense of gratitude and irredeemable indebtedness to my student friends who are mainly instrumental for what I am now. Now this topic for discussion is crime, meaning, definition, and elements. Crime is a public wrong. Crime is a public wrong. It is also known as offense. The word offense is used in criminal law codes, Indian Penal Code and Criminal Procedure Code, and all the special legislations relevant to criminal law, Dowry Prohibition Act, Domestic Violence Act, Prevention of Corruption Act, Forgery Act, and all. There are so many special legislations, and all the main legislations, that is Indian Penal Code, Criminal Procedure Code, and various special legislations of criminal law, the word offense is used. Neither crime nor public wrong is not used. Here, the word crime is derived from Greek word krimos, which means social order. The word crime denotes denotes breaking of social order. That is, in otherwise, crime relates to social disorder. The social order gets disturbed as a consequence of the incidents of crimes. So, this crime is a public wrong in the sense it causes injury or damage to the public at large, society as a whole. That is why, in that way, it is called murder, rape, kidnap, abduction, black marketing, theft, robbery, dacoity, These are the various crimes. They cause injury sometimes to one individual, group of individual, and society as a whole or public at large. Murder, A kills B, and it causes injury to B and his family members. Similarly, it is an offense against public. Black marketing, white collar crimes, so dacoity. There are so many offenses against the public and public rights, garrows, unlawful assemblies, like that. So crime is a public wrong in the sense it the consequences of crime are very severe and serious when compared to other wrongs like tort, breach of contract, breach of trust. Tort, breach of contract, breach of trust cause injury to one individual, group of individuals, whereas crime causes injury to one individual or group of individual and society as a whole or public at large. That is why crime is described as public wrong. Public wrong. Another reason for calling this crime as public wrong for the sense any member of the public can move the court. Any member of the public can initiate criminal proceeding in respect of a crime. For example, suppose a motorcyclist snatches a chain from a woman walking on the road, and another man who is witnessing this chain snatching can follow that the chain snatcher in his motorbike, catch him, hand him over to the police. Suppose a theft or robbery takes place in neighbor. If the culprit is found, any member of the public can place him before the police or place him before the magistrate lodging a complaint. So that is in that way the crime is also called public wrong. Public wrong. However, the word public wrong or crime is not used in Indian Penal Code or Criminal Procedure Code or many legislations like Dowry Prohibition Act, Domestic Violence Act, Prevention of Corruption Act, and all these Evasion Measures Act, Forgery Act, Essential Commodities Act, Cosmetics Act, whatnot. There are so many acts are there, special legislations. The purpose of special courts and special legislation is to try the case at the as early as possible. Decide the case as early as possible. As you know, my friends, there are more than 5 crore cases pending in India. The judicial authorities also are advocating, suggesting the parties to litigation and crime to settle the matter outside the court. Despite the emergence of so many alternative arrangements for disposal of the cases like lok adalats, fast track courts, consumer forums, tribunals, and all. The incidence of the pendency of cases has not yet been cleared despite emergence of so many special courts and lok adalats. So that is why these special courts and special legislations are designed to speed up the disposal of the cases. Now coming to the point, so in every main legislations like IPC, CRPC, and special legislations and the many other special legislations like Dowry Prohibition Act, Domestic Violence Act, the word offense is used. So the crime crime is an act or omission. So commission of an act and omission of an act results in some injury or damage. It is called crime. So commission of an act in the sense doing an act which you ought not to do, that is the negligent operation by doctor resulting in the death of the patient is commission. Omission, after surgery is completed successfully the doctor, surgeon instruct the nurse to administer oxygen or oxygen, saline and other injections like this from time to time. This nurse, having indulged in conversation with friends, having forgot to administer, that resulting in the death of the patient. That is what's called omission. An act which ought to be done is not done, is omission. Which an act which ought not to be done, ought not be done, is commission. Sometimes commission results in wrong, omission results in wrong. That is, if it is public wrong causing injury or damage to the public as a whole or society at large, that wrong is called public wrong. So the law relating to crimes is governed by criminal law. There are various branches of criminal law. Basically, there are two main branches. One is the Indian substantive law of crimes is Indian Penal Code, and procedural law of crimes is Criminal Procedure Code. The substantive law of crimes, Indian Penal Code, defines various offences and prescribes punishment for the respective offences. Whereas the procedural law of crimes, known as Criminal Procedure Code, which was passed in the year 1973, that came into force from 1st January 2074, lays down the procedure how to determine a particular act as particular offense, whether it is culpable homicide or murder, kidnap or abduction, a dacoity, robbery, extortion. What is that? So, in order to determine, some procedure is followed. When to make the accused in order to confirm an accused as a guilty person, in order to convict him, this some procedure is to be followed. That procedure is provided for under procedural law of crime, that is Criminal Procedure Code. When an offence takes place, immediately the information is given to police for filing FIR. The complaint may be directly lodged to the magistrate for taking initiative. Then inquiry will be there. Investigation will be there. Inquiry will be there. Bail. Giving in which cases bail is to be given, in which cases bail is or trial and trial judgment, whatnot, charge sheet filing, charge sheet, all these things. The entire procedure is provided for under Criminal Procedure Code. That is why this Indian Penal Code is substantive law of crimes. It defines various offences and prescribes punishments for the respective offences. The procedural law of crime, Criminal Procedure Code, lays down the procedure for criminal law machinery. So now coming to the next, these criminal IPC criminal law is one of the branches of public law. Is one of the branches of those laws which deal with the relationship and between state and public people. They are called public branches of public law. Those branches of law which deal with the relationship of individuals concerned, they are private laws. Law of contract, transfer of property act, personal laws, they are all personal laws. They are all private laws. Personal laws, they are tried in civil courts. They are tried in civil court. First stage, when the parties are called, both are private parties. One party is called plaintiff or defendant. In some cases, petitioner and respondent in matrimonial cases, if filed in district court or family law court. In some cases, if you directly filed in a High Court or Supreme Court, petitioner, respondent, we call. Whoever loses the case prefers appeal before the higher court is called appellant, and other party is called respondent. That is the position. So if the case is won, in a civil case, if the case is won, plaintiff decree or order given in favor of the plaintiff. If the case is dismissed, the case is given in favor of order. Case is decided in favor of the defendant or respondent. That is the case may be. Whereas both the parties in other private wrongs, private litigation, civil litigation, there will be two parties. One is plaintiff and the other is defendant or petitioner or respondent. Whereas in criminal law, one party is one party is accused, and other party is the state. One party tries to escape from the liability by employing a defense lawyer, whereas other party on the other side, the public prosecutor acts on behalf of the state government to convict the person. The duty of public prosecutor to act on behalf of the state to convict the to give punishment, prosecute the accused person by proving him as guilty of a particular offense. So here this thing. In civil litigation, the compensation penny given is awarded by court goes to the aggrieved party, that is the plaintiff. But in if fines, if any, imposed, go to the state in most of the cases. In so many exceptional cases, the punishment, if it is the law for a false punishment as per CRPC, it goes to the aggrieved party, defendant. In some cases, in view of criminal amendment 2013 and 2018, in offences against women, rape and modesty of women, those cases, the high acid attacks 370 and all these things, the punishment is made very severe, and life imprisonment in the sense 20 years and above 20 years till natural till residual part of the life, death sentence. So all these things I will take up in the respect to specific offences. But now here in such cases, the compensation awarded in criminal law goes to this thing. So this is the position with reference to what is crime, the meaning of the crime. Now coming to the definition of crime, many authors define crime in various ways. Sir William Blackstone, Kinney, Austin, Salmon, and other, so many Caton, so many distinguished jurists have defined this crime. But a very easy definition given by Sir William Blackstone in his book Commentaries on England. Crime is an act or omission in violation of public law, either forbidding or commending it. That is the definition of Blackstone. Blackstone said that crime is an act in violation of public law. It may be commission of an act or omission of an act. Either commission of an act or omission of an act constitutes an act. That act is done committed in violation of public law, against the law of the land. Either forbidden or commending. The state or state law prohibits certain activities, so and so act should not be done. So contrary to that order of the state, if an act is done. So even once the act is committed, the court will take, the police will take cognizance of the offence to initiate criminal proceeding and see that he is punished for that particular offence. That's why Sir William Anson in his book Commentaries on England defined this concept crime as an act in violation of public law, either commanding or forbidding it. This is what is the definition, and other definitions are almost identical. You may proceed. And now section 40 of Indian Penal Code define the Indian Penal Code also crime is not defined. In so many legislations or acts, either section 2 or section 3 of that particular act gives so many definitions that is under interpretation clause. Indian Penal Code section 2 defines various concepts. Criminal Procedure Code section 2 defines various concepts. Section 3 in Transfer of Property Act, section 3 in Evidence Act define various concepts. But here, according to section 40, this word crime is not defined in Indian Penal Code under section 2, but according to section 40 of the Indian Penal Code, any act which can be punished under Indian Penal Code can be regarded as crime, even it can be regarded as an offence. So the word public wrong or crime is not used in Indian Penal Code, but whatsoever act that can be punished, either act or omission, if it can be punishable according to Indian Penal Code, that particular act can be treated as offence. That is offence. According to the section 2N of Indian Criminal Procedure Code, also the procedural code defines crime like this. So what is that? Any act or omission in violation of law of the land. That is any in law of the land. All laws which are enforceable means they are codified and Lok Sabha, Rajya Sabha, April 2/3 presidential assent, gazette notification with what effect? They are called laws that are enforced to be applied in courts. That is what is called any act or omission which is against in violation of law of the land in force. That is in force means that is law is in life, that is not repealed or replaced by new act. This is about definition. Now next we go to elements of crime. Elements of crime. To constitute crime, four elements are there. In some books, two elements are there. Actus reus and mens rea. In majority books, four elements are there. It is better we study four elements. To constitute crime, four elements must be there. We know to constitute a cycle, wheel should be there, mudguard should be there, handle, seat, all put together. Cycle can be designed. Cycle can be made. So like that, to constitute crime, some elements are to be there. If all these elements, all these constants, these requisites, conditions are fulfilled, then only it can be treated as a crime, that is offence, either in Indian Penal Code or Criminal Procedure Code or any special legislation. Number one is human being. Second one is mens rea. Third one is act reus or physical act. Fourth one is injury. Now coming to the first one is human being. Human being means to constitute crime, that is offence, the wrongdoer must be human being and aggrieved must be human being. A killed B, A raped B, A kidnapped B, A committed theft in B's house. So the wrongdoer is a human being, aggrieved party is a human being. If a man kills animal, it is not crime in some cases. If an animal killed man or woman, it is not offense. Suppose one dog bites and the man dies. So the owner of the dog is liable, civil liable. He will have civil liability under law of tort. He will have to pay compensation. Suppose the buffalo or cow or ox of the owner entered into the fields of B and nibbled the crop, then the owner is liable. So if an animal commits causes crime, its owner will have liability, that is liability for animals under Sainter rule. Fera nature and mensute nature is there. With the animals which are dangerous by nature and the animals which are not dangerous by nature, I taught in this law of torts, Sainter rule. Now coming to the point, suppose if a man kills animal, it is not some goat or hen or cock. No, some animals are killed, there is no offense. But certain animals like deer, tiger, lion, peacock, they are killed. It is an offense. Because the Wildlife Protection Act 1972 said that killing of certain animals, birds, amounts to crime. It is an offense and is punishable according to that special legislation, Wildlife Protection Act. You know our famous hero, Bollywood hero Salman Khalji had to face lot of problem for having shooted a deer in Jodhpur. So this is that is why. So this Wildlife Protection Act is designed to protect the environment. Protection of environment is sine qua non for peaceful survival of the human being, because environment, so we have to protect animals, wild animals, birds, waters, tanks for small tanks and all, to protect the environment, forests and all, to protect the environment for the peaceful survival of the human being. So that is why so many environmental legislations are made. There are more than 200 legislations to protect the environment, but for 12 to 14 of these legislations you will study in environmental law. This is for this so far as human being is concerned. But however, in olden days, if an animal committed a crime, if any animal killed a man, that animal was killed immediately, and its flesh was not eaten by the people. Suppose, some buffalo or cow or ox killed a man, then it was beaten to death, and its meat was not eaten by the people. It was the body was abandoned. So that type of punishments were given in olden days. Now, according to Section 11 of the Indian Penal Code, Section 11 of the Indian Penal Code defines person. So the person, so to constitute crime, both the parties must be human being. But even though there are a natural person, there are certain artificial persons also come within the meaning of this person. According to Section 7, a company, corporation and all, they are artificial persons created by law with perpetual existence and common seed. Suppose a man speaks bad about a company, its director it is a crime, it is a defamation. It is against so and so, the products manufactured by so and so company are very dangerous. Don't use that product, produce it. It will affect the reputation of that company. That the director can bring an action. The person who made that defamatory statement about the quality of a particular product manufactured by a particular company is amounts to crime, and he is punishable. So that is why sometimes human being, we cannot say that it is only there is no hard and fast rule to confine this human being only. Person also is there. Artificial persons also will come, can be included. So this is the position. Suppose on the behalf of company or corporation, suits a company or corporation can sue and be sued for defamation, that is libel, which is a tort as well as crime. Now, next, first point, human being is over. Second point is mens rea. Second point is called mens rea. Second point, mens rea means mental element, evil element, guilty mind. An act itself is no wrong unless conquered by guilty mind. An act itself is no wrong unless conquered by guilty mind. If you do any act, that act will become wrong if you have a bad mind only. This is enshrined in a Latin maxim, actus non facit reum nisi mens sit rea. An act itself is no wrong unless conquered by guilty mind. When you do an act, if you have bad intention, then only your act causes and results in any consequence, adverse consequences causing injury or damage, then only your act can be treated as crime or offense. Suppose if a man while doing an act doesn't know about the act, doesn't know about a particular act, he is no way concerned. A man doing an act, what he was doing, he doesn't know that it is not that, but he was doing some act, but he doesn't know what he was doing. But it results in some loss or damage, causing some loss or damage to somebody. That act is no way is act. Suppose suppose a man is driving the vehicle. He drives the vehicle carelessly and out of ego and rash driving, this thing that, then any accident takes place, a man, bystander or pedestrian, the vehicle hits that pedestrian and that pedestrian is knocked down and died. Then he is liable because mens rea is there, mental element, guilty mind is there. Suppose when he is driving the vehicle, a tree on the road fell down on the vehicle, and the vehicle is toppled down and dashed some pedestrian on the road, or 1 or 5 persons on the road and died. It is an inevitable accident, and he can be exempted from criminal liability under section 80 general offences. Suppose the act is rash and hand rash driving means it is negligent right driving, rash driving, and punishable up to 3 years under section 304A. Suppose a person, as we see in some movies, intentionally taking vehicle to kill somebody, that is culpable homicide or murder, depending upon the nature of the situation. We are going to discuss. So that is why. So actus reum accept non facit reum nisi mensit reum means an act itself is no wrong unless conquered by guilty mind. So guilty mind should be present, then only it is an offense. Otherwise, if guilty mind is not there, it's no. So that is the position. Suppose that is why in accident, inevitable accident, the person is totally exempted from liability under section 80 of the Indian Penal Code. If there is a guilty mind, rash driving, he is punished under section 304A. Suppose here there is a intentionally wanted to kill somebody, he may be punished under section 300 for murder or 304 for culpable homicide, depending upon the situation. So that this concept, that is why basing on this, if a person is doing an act that what he was doing he doesn't know, it results in injury, that act is not at all his act. It was enshrined in a this was enshrined in a maxim. This was enshrined in some maxim, Latin maxim. I want to tell you. That is actus me invito, factus non est means actus. So if I do an act that I don't know what I was doing and resulting in accident, any wrong, it is no act. This means actus me invito, factus non est mens actus, mean an act done by me against my will is not my act at all. An act done by me against my will is not an act done by me at all. If an act is done with my will, it causes injury, I am responsible. If I do an act, I don't know, that act is not mine, unconsciously it is done, is not. For example, suppose a man wants to kill B, he takes full bottle of wine and will go to B and kills him. He is liable because it is voluntary intoxication, there is no exemption. But somebody in a party, somebody pours somebody mixes some intoxicated drug or substance in cool drink and gave him. That man doesn't know, he was fully unconscious, what he was doing he doesn't know. If he commits any wrong, he would be exempted from the criminal liability. So voluntary intoxication is not a defense, but involuntary intoxication is defense. This is what we will study under section 85 and 86 under general defenses of the topic. So this is about mens rea. So what is this mens rea? What is the definition of mens rea? Though there is no any definition of mens rea, there is no any proper test for mens rea. The concept of mens rea, that is guilty mind or evil mind, cannot be, it is very wide. It varies from time to time and situation to situation and offense to offense. For committing a pickpocket, the mens rea is this much. Pickpocket means when a pickpocket is done, the owner of some purse is plucked out or money in pocket is plucked out, that man is not injured. Suppose a woman is going on the road where her gold chain is removed, snatched, then some injury may take place to her neck, blood may follow. That mens rea is more serious. To commit an act of adultery the seriousness is more, mens rea is more. To commit an act of bigamy, marrying again a woman during lifetime of a spouse, that is more serious. To commit hurt or grievous hurt, breaking head or disfiguring, culpable homicide, murder, the mens rea is more. So for theft, mens rea is less. Robbery, mens rea is something more. Dacoity is the mens rea is much more. So that is why the volume of mens rea, the veracity of mens rea, the extent of mens rea varies from offense to offense and situation to situation. That is why the mens rea is not defined in an appropriate, in a comprehensive way. However, this concept of mens rea is strictly followed in English, England, and India also. But one thing, there are, suppose mens rea is present, the person is punished. If mens rea is not present, man is not punished. For example, a man driving the vehicle, suddenly on the road, a tree fell down on the vehicle, and the vehicle toppled down, and in order to escape, that man turned right side or turned right and run over by somebody, and that man died. It is an inevitable accident. It is while driving the vehicle, a man gets heart attack and accident takes place. It will be an inevitable accident. He can plead the defense of accident under section 80 of the Indian Penal Code to get exemption from the criminal liability. Suppose a man negligently drives the vehicle and dashes, he is liable, mens rea is present. Suppose a man intentionally takes vehicle to kill somebody, as we've seen in some movies, that is culpable homicide or murder. So that is why the mens rea defines varies from situation to situation. So this is the position with reference to mens rea. Now, in the position of mens rea in England it is it is strictly followed. But there are two important cases. Prince vs. R versus Prince is one case. R versus Tolson is another case. In R versus Prince, what happened was R versus Prince is one case, and R versus Tolson is another case. So in Prince case, R versus Prince. R means state. Prince means an young man. One Mr. Prince, an young man, fell in love with a woman, Annie Phillips. An young girl was there. She was called, her name is Annie Phillips. An young man fell in love with an young girl below the age of 16 years. Her name is Annie Phillips. Both loved each other. They wanted to marry. He ran away. The prince took away her from the lawful custody of her parents to marry her. But the parents of Annie Phillips, girl, lodged a complaint with police, and Prince was caught and tried for offense of kidnapping. And Prince said that I took her with good intention. I don't have any bad intention or mens rea. I wanted to, I'm in love with her. I wanted to marry her. She told me that she is above 18 years. I never thought that she was below 16 years. She looks like above 18 years only. Mens rea is not present in me. I may be exempted from criminal liability, he contended. But the court has said that taking away an unmarried girl below the age of 16 years itself is an offence. Whether mens rea is present or not is immaterial. And the prince was found guilty for kidnapping and was convicted, prosecuted. That is the judgment given. There is another case, R versus Tolson. Tolson and Mrs. Tolson got married. Mr. Tolson, he went to voyage. The ship in which he went to voyage was drowned. It was presumed that all the crew and passengers in the ship were presumed to be dead. So Mrs. Tolson honestly believed that her husband died in shipwreck, and thereafter, after we firstly there is a common presumption that all are traveling sailing in that ship were drowned and killed. That is one presumption. Second is she waited for 7 years. If the whereabouts of a person are unknown for a period of 7 years, that person is presumed to be dead or deemed to be dead, and the person presuming that her spouse is no more, either man or woman, can go for remarriage. Similarly, Mrs. Townsend, waiting 7 years, got remarried. When she started living with her second husband, first husband appeared, and first husband appeared. Then the first husband filed a case against Mrs. Tolson for bigamy. Having two wives or two husbands is bigamy. Having one husband or one wife is called monogamy. Monogamy means only one life partner. Bigamy means having two life partners. Having marrying again during lifetime of life partner, man or woman, it is bigamy. More than two wives, polygamy. More than two husbands, polyandry. More than two husbands is polyandry. So here Mrs. Townsend was charged for the offense of bigamy under section 57 of Offences Against Person Act 1861. But the trial court awarded 1 day imprisonment. She preferred appeal before higher court, and the higher court, that is Court of Appeal, quashed that 1 year imprisonment, stating that Mrs. Townsend, in case of Mrs. Townsend, mens rea was not present. Mrs. Townsend was not guilty in getting remarried. She is not guilty of bigamy. That is the decision. So, similarly, in wheat and stock is one more case wherein, relying on the statement of his advocate, one client, one advocate said his client that he has been granted divorce, but official decree for divorce was not given to him by court. But relying the words of advocate, he got remarried. When he was charged with the offense of bigamy, actually there was no any order to that effect. It amounted to bigamy, and he was prosecuted. So what is the position of mens rea? The question may be asked on mens rea alone. You have to write all these points. And similarly, another one more thing is, in this thing, second point is how mens rea is applied in England. In England also mens rea is well applied, and mens rea is treated in England. In India also mens rea is followed, and if a person is guilty of evil mind, he is punished. If not guilty, he is not punished. However, there are certain exceptions. There is one is Srinivasmal case is there. Srinivasmal versus Srinivasmal case, Srinivasmal versus Emperor, the 1947 case. What happened in this case was, in India, Srinivasmal was a salt vendor, but in his shop there are so many goods and consumer products are being sold. But without the knowledge of the master, servant adulterated some food products. But the servant mixed some less quantity food grains in more quality food grains to get personal benefit. It is what this was not known to the master. The checking squad inspected, food inspection squad inspected and detected the adulteration of some food grains, and it was found that the owner of the shop did not have any guilty mind, mens rea, and he was not made liable for the offense of adulteration of food grain. But that servant can have the personal liability. He will be found guilty and he will be arrested. So these aspects we will study in vicarious liability also. Next one is Rahul Hariprasad Rao versus State is one more case in India. Rahul Hariprasad versus Rahul Hariprasad Rao 1951. Rahul Hariprasad Rao was having a petrol pump, and during scarcity he was asked to distribute motor spirit against ration books, and there was the servants had to give water spirit through the coupons issued by coupons countersigned by the owner only, but there was a misuse of issuing motor spirit without coupons also. Motor spirit was issued for genuine persons. Motor spirit was denied. That is why the person who are standing in queue are not getting ticket, and somebody who is entering directly into booking office inside, they are getting tickets like that. But here case was filed, and this in this particular case master is guilty, because without the knowledge of the master, the misappropriation of supplying motor spirit cannot be taken place. That is why in this particular case master was held liable as an abettor. So this is what. And next one is Nathulal versus State of Madhya Pradesh 1966 Supreme Court. What happened that this Nathulal, accused Nathulal in the present case, applied for he is the dealer of food grains. He applied for sale of business of food grain. He applied for license to the government and paid requisite fee. He was waiting for the license. Meanwhile, he purchased food grains and stored them in godowns. Meanwhile, food inspection officials inspected his godowns and found the food grain. And without license, you are dealing with the sale of good food grains on the ground. The case was booked, and he approached up to Supreme Court, and Supreme Court said that he did not have any mens rea, he did not have any guilty mind. He honestly believed that he applied for license, paid requisite fee, and was waiting. He procured the food grain, and he did not. And whenever he procured the food grains, the purchasers returns he was submitting to the appropriate authority. There was no guilty mind on the part of this Nathulal, and he was acquitted from the liability. Like that, similarly, so many cases are there. That is Malhan versus Malhan KA versus Kora BB Kutti. In this case, the accused in this case gave finance to the purchase of vehicle, and that the borrower did not pay installments to the money lender. After waiting for a long time, the money lender seized the vehicle. The owner of the vehicle who took loan, that is borrower, debtor, lodged a complaint against the financer, stating that he has committed theft of that vehicle. On investigation, it is found that there was no guilty mind on the part of the money lender, and he was acquitted. There is no mens rea was taken into consideration in this. And the next point for discussion is actus reus or physical act. Actus reus or physical act is the next. Actus reus means physical act. The physical act may be tangible or intangible, visible or invisible. When once A committed an act or omitted an act, it results in cause or damage to another person. It is a physical act. Giving poisoned food and killing is commission of an act. Killing without giving food by locking a person, that is omission, and making such statement and causing injury or damage to reputation, it is intangible. Goodwill, reputation, they are intangible. They are neither visible nor touchable. What is the reputation? Can anybody see? What is the goodwill of a company? Can anybody see? Can anybody start? So intangible means which cannot be touchable, which cannot be seen. The thing that cannot be seen or touched, that is intangible. Tangible means can be seen and touched. Visible means seen. Invisible means cannot be seen. So that this actus reus includes physical act, mental act and a psychological act. That is mental act in the sense psychological act. It includes commission, omission, and even psychological acts like psychological phenomena like what we call these reputation, goodwill loss. For that also, criminal proceedings can be instituted. Om Prakash versus State of Punjab, what happened in this case was one husband, the accused husband in the instant case, locked his wife without giving food to her, and she broke open the doors and survived for survival and lodged a complaint with police. He was charged for attempt to murder and was convicted. So next last point for discussion is injury. So the injury to constitute crime, the loss or damage must have been taken place as a consequence of the wrong committed by the accused. It is the aggrieved victim suffers loss or damage, personal damage, mental damage, property damage, whatever, it is only due to the wrongful act offense committed by the accused person. That is there. So the injury must be proximate. For example, if life policy is taken covering all perils, natural death, accidental death, if that man dies due to natural death or accidental death, then insurance company will pay. Similarly, we take medical policy, medical insurance. The medical insurance means yearly some premium is paid. If the policy holder gets any disease, hospitalized, then only insurance company will pay the money. If he is healthy, he doesn't have any disease, not hospitalized, that premium will go to income to the insurance company. Similarly, accident policies, some banks are collecting little amount for accident policy. If the account holder died due to accident, the bank will pay some 1 lakh, 5 lakh or 10 lakh as the case may be. That is what is called accident policy. Some 5 lakh material is transported from Bombay to Calcutta. For that some insurance is paid. If the shipment reaches Calcutta safely, then the insurance premium will become profit to insurance company. Suppose that that shipment got damaged in the transit, and to what extent the loss takes place, that loss is to be indemnified by the insurance company. This is the position with reference to this causa proxima. Injury non remota causa proxima spectator. The law provides remedy for the proximate loss and not for the loss which is too remote. This is proximate damage. So that is injury. So this is the fourth point also is over. What is injury? Section 44 of Indian Penal Code speaks about injury, that harm to body, mind, reputation or property. Harm include harm to body, harm to person, harm to mind, harm to reputation, harm to property is harm under section 44 of the Indian Penal Code. So four elements of crime have been completed. First one is a human being, including person under section 11 of Indian Penal Code, which speaks about artificial person, company or corporation with reference to defamation suit. Second one is mens rea, common law doctrine of mens rea. In common law doctrine of mens rea, alone question may be asked. You have to write it in detail, and other points you have to mention in 1 or 2 lines. Third one is actus reus, physical act. This may be asked at short notes. And fourth one, injury or proximate loss. That is 4 points. Next, last topic for discussion is stages in commission of crime. There are 4 stages in commission of crime. First one is intention. Second one is preparation. Third one is attempt. Fourth one is accomplishment. This topic is very small. Intention. So what is intention? A wants to kill B. A is thinking in his mind to kill B. A is a politician, B is a rival politician. So long as he is alive, I won't be able to win the election. I want to kill. It is in his mind. That is intention. So intention cannot be detected, and at intention stage, the accused cannot be punished. However, there are serious offences like waging war under section 121 to 123 speaks about waging war. Section 124 speaks about sedition. Sedition. For these offences, they are very serious offences against the state or government. So, if in intention level also, if intention is detected, then those persons are the culprit is the accused is punishable with life imprisonment or death, as the case may be. So, intention level only those things. Second one is the preparation. Preparation also it is difficult to find out in these serious offences, sedition, waging war, attempt to wage war, conspiracy with reference to that also. If preparation level it is found out, they are punished. There is one more thing, at preparation level one can be punished. For a board exam, as per election laws, money should not be distributed. Money distributed 2 days before the polling time. The election campaign should be stopped, and the parties contesting candidates will approach the voters to seek their cooperation. In that process, before the day of election, huge sums of money is being transported, and we find in newspaper and TVs that in the so and so police caught a vehicle carrying a few lakhs or few crores to be distributed for water. Such money is distributed. So the distribution is not taken place, attempt has not taken place, but the preparation, that is what is called the preparation level, the person, the owner of the cash will be charged with the offence under election laws. Section 170 expanded section 170 A to I. So this is the position. So now in preparation, in that way the preparation level. But the sedition and waging war at preparation level, intention level they are punished. Preparation level automatically they are punished. Third one is attempt. A man attempted to kidnap a child. When he is about to run away, somebody found and caught him. That is called attempt. Suppose A wants to kill B, he fires a bullet, but it is missed. That is attempt. So A wants to kill B, he throws a knife or axe. It missed. B missed, B escaped. That is also attempt. So A dropped, A gave poisonous food to B to kill him, but before that, that bowl containing poisonous liquid fell down. Meanwhile, some cat or rat happened to drink that particular poisonous milk and died. That is also attempt. The person who gave milk bowl can be poisonous milk bowl can be prosecuted for attempt. So whatever is the punishment for completion of the crime, the same punishment is given to attempt also. What is the punishment for murder? Attempt to murder also same punishment will be given. Last one is accomplishment of crime, or this attempt to crime is called inchoate crime or incomplete crime. This fourth one is accomplishment, means the crime is completed. A wanted to kill B, accordingly A killed B. A gave poison to B, B killed. And A stabbed B with a deadly weapon and B died. That is what is called accomplishment. So these are the 4 stages: intention, preparation, attempt, and this thing. So last point is distinction between crime and tort. Crime and tort, that is the nature of tort. The nature of crime can be distinguished by explained by distinguishing crime with tort, breach of contract, breach of trust, and all. So first one is tort and crime and tort. Crime is a public wrong. It causes injury to one individual, group of individual, or public at large, or society as a whole. But tort is a a civil wrong. The tort is tried in civil court only. The remedy in tort is as a specific performance or restitution of property or compensation or abatement of nuisance like this. In crime, the remedy is punishment and fine. In some cases, the fine goes to government. In some cases, the fine goes to the aggrieved party. In view of latest Amendment Act 2013, which brought about drastic changes in IPC, CRPC, and Evidence Act, 2018 Amendment Act brought about drastic changes in four acts and IPC, CRPC, Evidence, and POCSO Act, protection of offences against protection of children against sexual offences act after 2012. After this legislation was passed after nearby case to ensure security, enhancing the punishment. All these things I will take up later, and this is the position. And one more thing is one more tort and crime. Tort is a public wrong. Crime is a public wrong. Tort is a civil wrong. The crimes are tried in criminal courts. Torts are tried in civil courts. In the remedy is punishment to accused in criminal law. In tort, it is only compensation is given. Compensation, restitution of property, specific performance is there. In crime, the damages, if any, generally the fine is awarded by court is goes to state in normal census. If it is a false complaint, that amount goes to, as per CRPC, that fine goes to the defendant against whom false complaint is lodged. In acid attack cases and other rape cases, the fine is imposed as life imprisonment is given or death sentence is given to the culprit, and also fine is imposed. The fine is of that volume for medical expenses, rehabilitation of the victim, raped girl, and all these things are there. Such amount awarded as fine goes to the victim. And in law, the amount of damages are unliquidated damages, means to be decided by the court depending upon the case. In criminal law, in rape cases and all, rehabilitation, medical expenses also will be termed as unliquidated damages, because depending upon the situation, what will be the volume of medical expenses, what will be the amount required for her survival in residual part of life, to be decided. The volume of compensation to be decided by the court depending upon the circumstances. Those damages are called unliquidated damages. In breach of contract, the damages are liquidated damages. Suppose the creditor gave 1 lakh loan to debtor did not pay, creditor filed a case for repayment. The court will give decree for 1 lakh, interest 10,000 rupees, court expenses some 10,000 rupees. The court may give, the court will pay around 1 lakh, give order for 120 lakh is what we can know in advance. If for breach of contract, breach of trust, how much money is misappropriated, and for breach of quasi-contractual obligation, what is the quantum of loss, can be detected well in advance. They are called liquidated damages. If the amount of damages can already be decided, can already be determined before filing the case, they are called liquidated damages. If the amount of damages or quantum of damages are to be decided by the court, taking into consideration circumstances of the case, those damages are called unliquidated damages. Suppose a man died in accident. What is the compensation payable? What is his age? If accident is not taken place, how long he will survive? How long? What is his earning capacity? What is his background? What are his dependents? Taking into consideration all these factors, the court will determine the damages to the next kith and kin of the a family. So this is the position with reference to this thing. So this tort crime, there are some differences are there, and crime, breach of contract, crime is public wrong, breach of contract is civil wrong, and civil wrong. This is almost common. The remedy is punishment in torts, so in a breach of contract also the remedy is liquidated damages, specific performance, like this. So these are the quasi contract. Contract means it is not a contract but looks like a contract. So what are the rights and obligations in a contract? Same rights and obligations are there in this thing. So in crime, one party is government and other party is accused party. The public prosecutor acts on behalf of the government to prosecute the accused person. But in tort and other civil wrongs, there are two parties. One is both are parties, private parties. One is plaintiff or defendant. One is the prosecutor, petitioner or respondent. One is appellant or respondent. They both are individuals only. But in criminal law, one party is state and other party is accused person. The accused person engages defense lawyer. The public prosecutor acts on behalf of the government to punish. So this is the position with reference to nature of this. This is what we have completed: meaning, definition, elements and stages of crime. Dear friends, from this topic, the question may be asked: define crime. What are the elements of crime? You have to answer for the topics. And sometimes the question may be asked on common law doctrine of mens rea. Then you have to mention the four names. You need not explain. You have to explain in detail about mens rea with maxims. English law and Indian law you have to write. That is mens rea. Common law doctrine of mens rea. Sometimes quotation is given: actus non facit rem nisi mens rea discuss. So this quotation refers to mens rea, or which means mental element or evil element or guilty mind. It is one of the essential elements of criminal liability. You have to write like that. This is the main thing. Other points you can mention in one line, but mens rea have to write it. Suppose the elements of crime are asked, we have to write all the 4 points. So criminal law, this topic is very very important from examination point of view. Is most likely question in any examination of every Indian university, and this one, and after this I will take up common intention and common object, section 34 and 149, Bharendra Kumar post office murder case, Mehboob Shah case are very good leading cases. And then I will take up next topic, this common intention, common object. Next topic for discussion is abatement. Abatement is next. Then right of private defense and section 84 general defenses. These are important topics. These, and vicarious liability very easy, and defamation chapter is very easy. I will take up all these topics. This one today, culpable homicide murder is the most likely question. Then in view of criminal amendments, so many drastic changes were made, and section 3 expansion of 354 criminal force against the modesty of women, that is section of 354 is more important. 370 acid attacks is very important. The rape, section 376 elaborately, so many sections are added. Rape definition is totally changed, punishments are totally changed, custodial rapes and all this thing. This is what you have to take up. Then dowry death you have to study, and then bigamy and marriage, adultery and bigamy. These topics are to be studied first. Next, you have to take waging war and sedition, first chapter. So these topics you prepare thoroughly. You will be in a position to face the examination. Please take care of the subject. Try to learn. So many students are asking so many UTs, this stuff, that said. At present, there are more. With this lecture, 122 lectures are there. See, 122 lectures. Out of these, around 50 are in English, Telugu media, and remaining lectures are in uh, English media. Nearly 150, 220 minus 50, 170 lectures are in English media on 18 subjects. If you can concentrate, you will be able to learn very good knowledge. This type of lectures are not uploaded because I hope that some teachers may take it as an inspiration and will start, so that student friends can be benefited. So please uh, respect our law course, which has been conferred supreme status. Thanks a lot.